good afternoon, and happy holidays to everybody out in webinar land. Thank you for joining us. My name is Eric Bowman. I am joined by my partner, Gary Forster. We are partners in the law firm of Forster, Bowman, and Lefkowitz, and we are today covering the 10th commandment in our 11 Commandments of Asset Protection series of webinars. We started this last January, and today we'll do Commandment 10. We're going to take the month of December off. Lots of folks have other things going on for the holidays, and rather than trying to squeeze this in between Christmas and New Year's, we're going to take the December month off and resume our webinar series in January. And we'll do the 11th commandment in January, which is don't invite others to the party. That one's going to be based around ethics, and we've applied for ethics credit for that. So folks that have a hard time getting those credits, please be sure to join us for that one. Meanwhile, as we start today, Gary, can you say hi to our audience?
Hi, how we doing? I think this is going to be an interesting commandment. Bankruptcy is really something we really try to avoid. When asset protection as a practice area started, bankruptcy was really considered an option when someone would come in pursued by creditors, even if they had significant assets. And what's developed over the years is that the bankruptcy courts, intending to have a lot of the debts, you know, which are going to be dealt with in bankruptcy, paid or discharged, have really done everything they possibly can to reach assets, in many cases otherwise completely protected. So it's really something now where we want to avoid having to make that choice. That's why we came up with this title. Bankruptcy is not a good option. You can do it, but it's very, very risky. And we'll try and set the table for a lot of the cases and give you a flavor for why that's really true now, and why you generally want to avoid, especially with a wealthy client, filing bankruptcy.
All right, and as another matter of housekeeping, I'm going to, let's see, we're gonna go ahead and drop in our slides and PowerPoint so folks who want to follow along in our written outline. Excuse me just a second while I exit out of here. That handouts.
So everyone can reach through the program all the slides and the outline.
Exactly.
Okay, great.
All right, back to our regularly scheduled program. Hopefully everybody can see us and hear us. If you can't, please leave a note in the box. And there's two handouts that we put in the box. So our agenda for today start with a little introduction, and we're going to talk about a couple cases with from bankruptcy courts. Go back and take a little history lesson. Talk about some bad results that have come out of the bankruptcy courts, explain why the rules are different in bankruptcy, and talk a little bit about planning to avoid bankruptcy. And we'll leave time at the end for some Q&A. And as we've mentioned before when we do these, if anybody has any questions along the way, please put them into the box in the webinar application, and we will try to address those questions as we go. And if you think of something after the webinar and you want to shoot us an email or a phone call, we welcome that as well. So first of all, as Gary said, bankruptcy is for typically for somebody who hasn't planned. If you have engaged in some asset protection, done some personal planning to protect yourself from disastrous consequences with a creditor, taken some of your assets and put them aside for a rainy day, and you did that at a time when you had no judgments, no lawsuits, essentially when the skies were clear, then you want to use asset protection as a way to create leverage with creditors and avoid bankruptcy. Bankruptcy courts are not kind to people who especially engage in what some call late-stage asset protection, which is really just fraudulent transfers.
So why don't we talk about the perspective of the court a little bit? I think a lot of times some of this detail it is hard to draw on because it's the perspective is very difficult. In other words, when someone goes to regular civil court, and if they lose their case, they have a judgment, and then the rules of asset protection and associated with trusts and LLCs kind of kick into play, and typically everybody kind of follows those rules, what's available, what's not available, and sometimes someone will have a judgment against a debtor, but the assets are protected, so there's nothing to reach. In bankruptcy, it's a little different. In bankruptcy, it only involves going into the court to have debt discharged, to be relieved of debt, but in exchange, to some extent, in exchange, you kind of have to give up what you have. So the idea is you go into bankruptcy, okay, I want my debt expunged, but the court's really a lot of times interested in, maybe, but what have you got? Because you're going to have to give up what you got. We're not just going to give you a freebie on not paying back these creditors. So it's federal court. It's not just collection in a civil claim. The rules are totally different. So the court is much more aggressive, and although the bankruptcy rules are different from what we find, in state or even federal litigation of regular claims, it's a cutting edge type thing, the bankruptcy court, because we look to the court because they'll take the next step toward being more aggressive toward reaching assets because the rules are different. And then in some cases, such as the single member LLC, which we'll talk about later, the state courts will do the same thing. So it's a little bit of a window into what's the next aggressive step that's going to be taken by a plaintiff.
Yeah, what Gary said is saying it a different way, or I'll try and say it a different way, and hopefully we don't beat this too much. But we look at bankruptcy cases because that gives us, from that they're usually the first ones to do something new, and that allows us to predict
collection-wise,
from a collection angle, from a creditor strategy perspective, what are the next moves? Where are the next risks coming from? And we find that the bankruptcy courts are usually the first ones to make a move, and then the state courts will follow. And whenever we're planning, we're always considering, how is somebody on the other side going to try to attack this? So let's go back into the actually 1989 is when when this person involved with Larry Portnoy created an offshore trust, and so that's when this starts to heat up. The offshore trust was used as a self-settled trust, and this still is used as a self-settled trust. In other words, it's where a grantor or settlor of a trust creates the trust with that same person, the creator, the grantor, as the beneficiary of the trust. In the United States, typically these were not recognized. You couldn't set up a trust for yourself, and in many states
you could do it, but if you were sued, the asset would not be protected.
Right. So it didn't create any asset protection. That changed with Alaska, and now there's several states, and we've had a separate webinar on that do allow self-settled trusts here in the United States, but you still run into the issue. For instance, we sit here in Florida. If you create a self-settled trust under Alaska law, but you move to Florida, or if you live in Florida, or if you're sued in Florida, will Florida recognize the trust? We think probably not. But here you have Mr. Portnoy created, at the time everybody would go offshore to do a self-settled trust, and he had an offshore trust, and he ended up being sued and for a guarantee on a loan to a Midland bank, and he ended up in bankruptcy. So he filed for bankruptcy, And the reason we look at this case is because this is one of the first ones where the bankruptcy court, of course it was a bankruptcy court, said, we don't care that you have a trust that says that it's governed under the laws of Jersey. And we don't mean New Jersey, we mean Jersey, which is an offshore island.
Yeah.
And you're here in New York, and under New York law, self-settled trusts are not recognized. They're against public policy. And so we can disregard the language in the trust that says we look to Jersey law, and instead, since you are in New York and filed bankruptcy here, we're going to apply New York law and essentially disregard the trust and treat the assets that were transferred to the trust as part of your own estate. Now, Mr. Portnoy had done some things wrong, of course. He created these trusts. He owed the money, or he was going that he had the guarantee outstanding, and he transferred substantially all of his assets. He was transferring all of his income. He was transferring all of his wife's income into the trust, and so that created problems as well because he had a fraudulent transfer issue.
So yeah, so this foreign trust, he made a mess of it, which a lot of these cases involve. This is not someone who's just typically planning. So before Portnoy, if someone was planning, they were not in litigation or had a claim against them, and they wanted to create a foreign trust, and they lived in Connecticut. I think Portman was from Connecticut. That was kind of the end of the situation. I mean, if he went to Jersey or Guernsey or wherever he wanted to go to create a trust, funded that trust with a trustee in that island, really there wasn't a lot of issue. I mean, if he later had litigation against him, those assets really are not available, and the case law prior to Portnoy pretty much made that clear. So when you form a trust, you choose the law applicable to that trust. The trustee agrees. You create the document. The arrangement is solidified in whatever jurisdiction you choose, and it's just not reachable. So what happened in Portnoy was that he chose to go into the bankruptcy court, which then led to this new idea that if you file bankruptcy and you have a foreign trust and you don't live in the jurisdiction of that foreign trust, the court, even though it's a federal court, sitting in the state where the debtor has applied for bankruptcy, can say, you know what, public policy says that we're going to apply Connecticut law. Even though there's a document and the applicable law is obviously Jersey, we're going to apply the law of where you're at, and we don't recognize self-settled trusts. And so we're going to go ahead and take all the assets in the trust. Now, if the assets are obviously offshore, they're not going to be available anyway. But what ends up happening is you have what's called the offset rule. So if there's $1 million available in Connecticut and $1 million offshore in the trust, they say, well, you've got $1 million offshore in the trust that you have to disgorge. You haven't done so, so we're going to go ahead and take the $1 million in Connecticut. Sometimes that happens. But this was the case that kind of turned this self-settled trust thing on its head. And actually, even today, when we're trying to figure out if the domestic self-settled trust, for instance, Nevada or Delaware, is going to apply, a lot of people go back to Portnoy and say, you know, if you don't live in Nevada when you create your trust, they're just going to disregard the trust and apply the law of the state where you live. So this is a very significant case, and actually there's several cases after it that pretty much affirm that you're a maniac if you go bankrupt, because they're gonna basically disregard your trust, and you're gonna lose everything.
Yeah, and how does the court get there? There's some language in the case where the court says, you know, under normal circumstances, parties are free to designate what state or nation's law will govern their rights and duties. But, and here's a quote from the case out of the Portnoy decision, in the United States, it has long been held that it is against public policy to permit the owner of property to create for his own benefit an interest in that property that cannot be reached by his creditors. So we'll hear that phrase over and over again as the against public policy, and that's how the courts are going to continue to attack asset protection structures. We have, apparently somebody who's having a hard time seeing this. According to everything I've got on the webinar screen, it looks like everything's working. Our sound, audience, we should be on, everybody should have a slide. I'm going to jump on the one from the picture, the one that says, it's got Roman numeral 2 at the top of it, case studies of disastrous results from bankruptcy courts. If anybody's not seeing that, and you could drop a little line in the note box for me, please let me know, and we'll try to address it. So anyway, let's move on in the webinar. Next case we talk about, our next situation we talk about is the bankruptcy courts will put you in jail sometimes for not complying with their rules. And we don't have debtors' prisons here in the U.S. We hear that frequently. But what we have is courts have authority to enter orders compelling debtors to turn over assets or repatriate or make assets available if the court thinks that the debtor actually has control of that asset. If you file for bankruptcy or not, if you have a judgment against you and the court thinks you've got a bunch of cash sitting under your mattress in your house, the court can order you to turn that cash over. And similarly, if you put assets in an offshore trust and yet you still pull the strings of the trustee or have control over that trust or influence so that those assets can be brought back to satisfy creditors, courts can put pressure on you to do that. And the example we use here, and we've talked about this case before, is in Ray Lawrence. And this is a case about Mr. Lawrence, who was on the wrong side of a $20 million plus arbitration award related to some trading activity with Bear Stearns, who's no longer around. And he had settled trusts in Jersey and the Channel Islands with a substantial portion of his assets. And the court said, although you can engage in pre-bankruptcy exemption planning, that's acceptable, whatever that means. And in the case of Mr. Lawrence, where he took substantially all of his assets and just moved them offshore to make them unavailable to creditors, the court wasn't happy with that, considered that, it considered his fraudulent intentions and evasiveness, and ultimately ordered that he turn over those, or make those assets available to his creditors. He refused, and the court entered an order of contempt against him, and under the contempt order, he was to stay in jail, and he was fined $10,000 per day until he complied with the order, and that order was entered in 2002. We have it. I think it was, he was spent, how long was he? No.
6.5 years he was in there.
Yeah, so he was in jail for about 6.5 years up until 2006 when he was finally released, and there the court recognized that the contempt order was not going to compel Mr. Lawrence to turn over his assets because he valued his money more than his liberty, is what the court said. So what do we learn from that? And Gary, you want to talk about this one a little bit more?
Yeah. So it's the same story basically. This guy had a huge amount of cash. He was being pursued by a civil plaintiff, Bear Stearns. He basically had a margin call that he didn't pay back, and he did like a hide the ball. He put the money in a foreign trust, and then he moved jurisdictions 2 or 3 times. He was very, very rough with the court too, which really created a lot of the detail to the case and a lot of the backlash he suffered in the bankruptcy court. And what he did, he moved to Florida actually. So the first thing he could have done is bought a mansion which no one could have touched because he wasn't in bankruptcy yet. And the reality was that at that time in the late 90s, to reach someone's assets in a foreign trust outside of bankruptcy, even if they had done a fraudulent transfer, would have been very, very tough also. But he got, I don't know if he was advised or he just decided to file bankruptcy. And once he did that, and it's kind of the moral of the story of this webinar, he totally changed the rules applicable to him with respect to collection. So Eric will tell you, because he spent years litigating this stuff, that a state court or even a federal court in a civil claim is very reluctant, and we actually have a recent case on this, so the Sargent case, very reluctant to put someone in jail with respect to their inability to comply with a collection judgment. Very reluctant. You rarely see that. They'll have the judgment. They'll tell the debtor, you really should pay this, and then it just becomes a collection action where the plaintiff goes after the assets wherever they are. There's injunctions. There's this, but no one really goes to jail. I mean, you basically never see that. I think in 23 years of practice, have you ever seen anyone go to jail for a collection action? In our experience, it's very rare.
No, in state court, it
very
doesn't
rare.
happen. There was a federal court case a couple years ago that we had talked about, the one involving travelers here in Orlando, where
it was threatened.
Where there was a contempt order was answered, but they turned over the assets.
It's very rare. So he probably would not have even gone. There probably would not have even been a threat of jail, but he went bankrupt, and he was really nasty with the bankruptcy court because he thought he had kind of won the game, and so no one's ever had this much time in jail, so it's just kind of an odd example, but it's an interesting example. So they told him, look, you're going to disgorge these assets. He said, I'm not the trustee. I don't control these assets. So a line of cases involving control started with Lawrence. I don't control these assets. The trustee controls these assets. And the court said, yeah, I think you do. You're going to jail too. You give them up. And he sat in jail. And he sat in jail for quite a long time on this civil contempt claim. You're really not supposed to sit in jail very long. The civil contempt is it's a way by which the court would convince someone to give up an asset, but if it's clear that it's not going to happen, they have to be let out of jail. There's no criminal claim. So he actually sat there for years, and then they let him out, and he kept his money. But it just shows you, if you just hadn't filed bankruptcy, you probably would have settled it out for pennies on the dollar. And there's a subsequent case. I don't think we do Anderson. There's an Anderson case where they didn't go bankrupt. Yeah, they didn't go bankrupt, and they settled it out with the Federal Trade Commission for pennies.
They went to jail.
They did go to jail for what? 4 months.
Anderson, they were in jail, but yeah, Lawrence is one of the longest.
Yeah, so they went to jail for 4 months and then settled it out for pennies on the dollar.
So understand that one of the another risk here with bankruptcy courts, it seems that the bankruptcy courts and in some of these big federal cases involving tax issues and the FTC, the trade commission,
yeah, I mean,
they are. That's a situation where you're much more likely to have somebody really dig into any planning that you've done, try to expose any weaknesses, again, what some people call late stage planning, any fraudulent transfers, and try to use leverage, including incarceration, to make you turn over assets. And the courts will say that, while we don't jail people for, if you really don't have control over the asset, then that's the argument that everybody makes. But if your lack of control is self-created, then you're likely to have a court not look kindly upon that. Let's talk about, let's hit another one here. Okay, this is the Hubert case. This is a trust case, and we use this just for an example of how a bankruptcy court in particular will get a little creative, even with the application of law, to get debtors to pay their debts. And in Hubert, this involved a gentleman in the state of Washington who had a substantial real estate holdings, and he
was a developer.
He came into some financial issues, but he created a trust in Alaska, and as I noted earlier, Alaska is the first state to recognize self-settled trust. So he created a self-settled trust in Alaska.
And here we were waiting again for law on self-settled trust, right?
Yes, and so this is one of the first ones to challenge, one of the first cases to challenge the domestic self-settled trust. And so here it gets challenged in the bankruptcy court, and what the bankruptcy trustee successfully argued in that case was, yeah, it's an Alaska trust, but one of the trustees was, I believe, his son, who was a Washington resident. The assets were in Washington. Huber himself was in Washington. He filed for bankruptcy in Washington. And ultimately, the court said, Washington has a strong public policy, there's that phrase again, against self-settled trusts. And we're going to apply Washington law here in Washington over this Washington resident and essentially disregard the Alaska trust and any language in the trust applying Alaska law. Anything to add to that, Gary?
Yeah, again, you see the bankruptcy court. We're waiting on law for the domestic self-settled trust. We have 16 states that offer. You can create your own trust in those 16 states, and we don't know. We just don't know how courts are going to react to them. So, as is typical, the bankruptcy court, which is highly aggressive, and wants those assets from that debtor, says, you know what? You better have your act together when you settle one of these trusts. If you're not living in that state, your trustee better be in that state. Let's say it's here, Alaska. You better have your assets in that state. Your beneficiaries better have a link to that state, or we're going to just say it's invalid. By the way, this is a tremendous legal leap of faith to go and say someone sets up a trust, they pick the law, they follow the statute, they comply with the statute in terms of setting up one of these trusts. It's valid on its face. But when you go into bankruptcy court, they can get creative and kind of do whatever they want. And the problem is that then the state courts tend to follow that line of reasoning. Eric and I have had a number of conversations on what's going to happen with the LLC. We do LLCs offshore and in different protective states. Is the LLC going to, that we do in Delaware, are the protections associated with that going to be invalidated if that Delaware company does business in Florida? We don't know yet. We don't know yet. But Eric will say, it's doing business in Florida, so probably subjects it to Florida law, even the protections. Even though that's kind of an internal statutory thing. I have trouble giving up this internal statutory provisions because that's kind of the way that the car is made. That's a Ford. I bought a Ford, but once that Ford enters Florida, it becomes a Dodge or something. I can't figure it out. But I can tell you this though: if you go bankrupt and this issue comes up with the LLC, which LLC applies, you can bet that the bankruptcy court is going to invalidate the protections in the protective state.
Yeah. So let me touch on that a little bit more because that's a great example. We just did a seminar for the Orange County Bar here a couple weeks ago. We were talking about some recent LLC cases, and we think this notion of we have LLCs were traditionally used as asset protection vehicles because you couldn't foreclose on an LLC interest. So we've done a whole separate seminar on this. I won't go over the whole thing, but just a little background for folks who aren't as familiar. So you can foreclose on corporate stock, but you can't foreclose on an LLC interest. And then there was a case. We talk about it in bankruptcy, 2003 in Colorado, in Ray Albright. In that case, the bankruptcy court was the first one to say, you know what? When it's a single member LLC, we don't have the same concerns about foreclosure of a multi-member interest, so we're going to allow foreclosure. Then you have Florida that followed in 2008 as a state court and said, well, it's been done before in the bankruptcy court. We're going to go ahead and foreclose on a single member LLC. So that's what Gary refers to as a single member LLC, and whether or not that's protective here if you become subject to a judgment or collection action, if you have an interest in a single member LLC, can a creditor take that? Some states have specific provisions that prohibit foreclosure of a single member interest, like Nevada and Delaware. Florida doesn't have that provision. So if you're here in Florida and you have a single member LLC, you probably want to create that LLC in a jurisdiction that recognizes the...
Will it work? I don't know.
Or it prevents foreclosure. But if you get sued here in Florida and somebody's trying to collect on a judgment or take some action against you personally, and you have an interest in a single member LLC in Delaware or Nevada or somewhere else that recognizes single member entity, will the court allow foreclosure? Will the court say, well, yeah, it's a Nevada LLC, but you're here in Florida, similar to the Hubert case. Our law here says that we can foreclose on that interest. And what Gary is saying, and this is probably a good prediction we can make, the first, when that happens here, well, actually, we already had a case. We had a case a couple of years ago where there was foreclosure, where we applied Florida law
to the nevis.
But in bankruptcy courts are much more likely to apply the local law. And then we're going to have the next step is, well, okay, you create a multi-member LLC.
Right.
And this we talked about at the bar. So if you create a multi-member LLC, let's add my wife as a 1% member. Let's add my kid's trust as a 0.1%. Now it's a multi-member LLC. Now there's no foreclosure issue. Well, not so fast. We've already seen a recent case with an alter ego and reverse veil piercing of an LLC in California, a multi-member, and we're probably going to see the multi-member LLC under attack in bankruptcy courts. I think it's going to be the bankruptcy courts where we're first going to see it. So, kind of divert a little bit, but I think that's worth. We'll probably do a whole seminar on that, and we are doing one, by the way. We do an LLC seminar in January, and we'll talk about that much more extensively. So. Continuing with this, now we're on to our next major subtopic, which is just talking about how the rules are different in bankruptcy. And the first one to point out is homestead. We talk a lot about the protectiveness of the Florida homestead right here. It's a constitutional protection, which means it can't be trumped by statutes such as the Fraudulent Transfer statute. However, the homestead is not protected as well in bankruptcy. There's a look-back period. There's limitations on what you can claim for homestead exemption in bankruptcy. So we want people to be aware of that if you're relying on the protection of a homestead and you move to Florida, like the classic case is the Habaco case that we've previously discussed, you move to Florida to protect yourself from creditors, you buy a big homestead, you don't want to go filing for bankruptcy because your homestead is safe under any Florida action, but as soon as you go into bankruptcy, you've now just put that at risk. There's a waiting period.
Absolutely.
Anything you want to talk about? Homestead is pretty straightforward. Let's talk about another self-settled trust case. Back to this notion of self-settled trusts not being consistent with the public policy traditionally in the U.S. and in several states, and we have the Mortensen case. Gary, you want to give a little background on that one?
Yeah, Mortensen was the classic blunder of bankruptcy. That's why we included it in the outline. So Mortensen was one of these guys. He was like living on the land in Alaska. He actually was living in Alaska with assets in Alaska. And he created this Alaska Self-Settled Asset Protection Trust. It's unclear whether he, it looks like it might have been a fraudulent transfer with respect to his upcoming divorce. It's kind of unclear. But he created the trust. It looks like all the pieces are in place. The grantor is Alaska. The assets are Alaska. The trustees Alaska. So it's enforceable. He gets into this divorce. It looks like she claimed a little late. Alaska's got, I think, the 4-year statute of limitations on fraudulent transfer. What that means is Mortensen transfers exposed assets into an asset protection trust, making them protected, right? If he does this with the intent to avoid his wife, then his wife can go get the asset. But she only has a certain amount of time. That time had passed. So it looked like he was going to escape the divorce claim, at least likely, by having formed and settled and funded this asset protection trust. But he had quite a bit of debt, and he went bankrupt. So he went bankrupt, and he shifted the statute of limitations from 4 years to 10 years. And so he got trapped in the fraudulent transfer, and he lost all the assets. it's just the classic acting without working through all the issues.
And back to specifically with regard to bankruptcy, with the new bankruptcy code in 2005. At that time, when the new code was adopted, there were already at the time 6 states that had adopted self-settled asset protection trust statutes. And so Alaska was one. I don't know what the order was after that, but there were 6 states at the time where you could now form a self-settled trust, where that traditionally wasn't the case. Go back to that Portman case we talked about back in the 90s. The court said, well, the U.S. doesn't have recognizes a public policy against the self-settled trust. Almost 10 years passes, now you got some states starting to pass the self-settled trust statute. And so when the Bankruptcy Code was adopted, they specifically put this language in there in Section 548E that was intended to address the states with self-settled trust provisions and to allow for a longer time period to unwind them. So you got 10 years in the Bankruptcy Code. Same thing again with homestead, is you've got some specific language in there that allows you to unwind transfers in the homestead. So the Bankruptcy Code is actually has rules in it. Not only do you have the courts who will interpret law differently, and bankruptcy judges are appointed. It's a lifetime appointment unless they resign or are impeached. So their federal judges are pretty close. Somebody said to me one time, why would anybody want to be a judge? And I'm not sure about a state court judge, but if you're a federal court judge, you're not subject to re-election. I mean, you just got to not. As long as you stay out of trouble, you can do whatever you want. That's like the closest thing to God. And so on top of the power that the bankruptcy courts have, you also have law that's specifically written to avoid some of the asset protection measures that people try to engage in. And what else do we have in bankruptcy? We have specific rules that say that it's a criminal act to try to conceal assets. If you get a judgment in state court, you have discovery, and we could take the deposition of a debtor, and we can subpoena bank accounts and get information that way. When I'm in that situation, I hire a private investigator. I have a couple that I work with, private investigators, asset search firms. We can dig and get information, and it's a cat and mouse game. I expect that even though the debtor is supposed to be forthright when you take their deposition, I expect that people aren't going to give me all of the information, or at least not make it easy for me. But in bankruptcy, if you conceal assets and you don't come clean, then because that's part of the deal. In order to get a discharge, you have to come clean in bankruptcy. If you don't do that, you can get in trouble. You can actually be you can end up in jail. Also, anybody who conspires with somebody to hide assets. So arguably the recipient of a particularly egregious fraudulent transfer, somebody who helps in fraudulent transfer activity, if it's particularly egregious, I could see a bankruptcy court going after them.
Yeah, I mean, we've had cases, many civil cases, where we just can't get that certain evidence. We ask for it, we plead for it, we beg for it. This happened, that happened. All of a sudden, whoever we're litigating against has lost it, or there's some kind. And basically nothing happens. But when that person decides to go bankrupt, they have to disgorge these assets, or they can go to jail, not just in contempt. I mean, they can be criminally convicted through bankruptcy, and spend a lot of time in jail. It's a huge decision. So go on to our next topic here, like this here. Bankruptcy courts will go where no courts have gone before. So we've kind of hit on that already a little bit here, and we got a little ahead of ourselves on the LLC. But here's the Albright case that we mentioned earlier, and that was the case. It goes back to 2003, Colorado Bankruptcy Court, and that was a case that started the attack on the single-member LLC. And at the time, Gary and I were at our prior firm, and we were advising. I know Gary was advising clients back around 2005, 6, 7, in that time period, to be wary of the single-member LLC, because we could see the attack coming. And sure enough, the Albright Bankruptcy Court started the trend. Some other courts followed, and that led to a change in the law here in Florida. We had the Olmstead
and we've got a revised LLC Act that was adopted in part here in Florida, and a Uniform Act.
It's another example of the aggression of the bankruptcy court. So you have these LLC statutes that create protections of equity in LLCs, and some mention single-member LLCs, some mention multi-member LLCs, but none of them that I know of say because you're a single member you're treated differently. So what happened is this woman, she was a movie star or something, this Ashley Albright. She goes bankrupt, and she's got assets in LLCs. I don't know, actually Colorado, I think they were Colorado LLCs. And she's the only owner. The statute says, look, if you have an LLC, it can't be foreclosed, it's protected. Doesn't talk about single members or multi-members, it's just all of them. But the bankruptcy court wants those assets. So it comes up with a little historical logic as to why the single member LLC should not be protected. It has to do with the old partnership laws. It has nothing to do with the LLC statute. All of a sudden, if you go bankrupt, you have a single member LLC, it's exposed, it's going to get foreclosed and taken from you. And then amazingly, the same issue comes up in Florida, and it involved a huckster was the problem. It was a guy who had swindled people, had assets in his single-member LLCs, this Olmstead. And they certify it to the Supreme Court, and the Supreme Court basically says, oh, a LLC is the same as a corporation, you can just take it. It made such havoc of the law, it was so off the cuff, that they had to completely revise the LLC statute to again protect the multi-member LLC, and unfortunately now in Florida the single-member LLCs looks like it's pretty much unprotected. So the bankruptcy court can be very powerful. It's a huge decision, right?
Yeah, and that really, it did. It changed law across the country because a new LLC Act came out of that. And we're, like I said, we're going to, I think, continue to see the attack on the LLC, and a lot of it's going to trace back to that same rationale. The Albright rationale is, it comes from the old partnership. The reason we didn't allow foreclosure on LLCs was is similar to not allowing somebody to take a partnership interest. If Gary and I are partners in a law firm and I have a creditor that I owe money to personally, it doesn't seem right that they can come take my interest in a law firm and now Gary's got a new partner at the bank. They don't know anything about practice in law, or presumably.
And they're not going to be as good as you.
They're not going to be as good a partner. They're not going to be as nice. They're not going to bring Gary his coffee in the morning. And but you know, that's the idea is you're protecting the innocent partner. It's this innocent partner conundrum, and that's why we didn't allow foreclosure. So in the single member,
that wasn't in the LLC statute.
No, it wasn't. And so, but that was the rationale. They said, well, in a single member LLC, you don't have the innocent partner conundrum. Well, now that's what we're going to see with the We're going to see husband and wife, multi-member, the father and trust, and they're going to say, well, you don't have an innocent part. You know, your 1% trust that your kid owns isn't an innocent member. And it's going to be a bankruptcy court that's going to really hack on that. So what else can the bankruptcy courts do that we don't see in state courts? Well, we've got this Cutoy case. We've talked about this one before, and this is has a colorful background. It was really some people who were looks like they defrauded somebody in California. They moved to Florida, tried to hide some assets, and it was a boyfriend-girlfriend situation. I think a couple.
They were very dishonest.
They went to an attorney in South Florida and had engaged in some fraudulent transfers and ended up filing for bankruptcy. And this really ended up, this is pretty disastrous, because what happened is in the bankruptcy, you had the bankruptcy trustee trying to obtain communications between their Florida Asset Protection Council and the debtor and the debtor's significant other, who was involved in helping to make these fraudulent transfers. And the upshot of it, and I know we're going to come to a close here in a little bit, so I want to get to the next case, which is Husky. But you have a couple things going on. One, the court says that a fraudulent transfer is a legal basis for exception, the crime fraud exception to attorney-client privilege communication. And let me back up. That requires a little bit more explanation. the attorney-client privilege here in Florida and most states recognize it as sacrosanct. Somebody comes in and talks to me about their case. I cannot be compelled by a court or anyone else, and I am duty-bound to protect that communication as confidential. So a court can enter an order, hey, Bowman, tell me what your client told you. There are exceptions to that, and they're very narrow exceptions, and the most recognized one is the crime fraud exception. And even that's not as broad as what it sounds. It's in certain circumstances of egregious crime where somebody might be hurt or where somebody gives information to their attorney, yeah, then you have an exception to the attorney-client privilege, and in certain circumstances of fraud, but it's egregious stuff.
Well, it's also,
and the courts don't apply. I never see it.
It's not if someone comes in and says, "I shot someone."
Right.
It has to do with, like, I'm planning to do this, and it's going to involve a crime. We have to tell people that may not be protected by attorney-client privilege.
We're gonna, I got this scheme to defraud, 100,000 people out of their credit cards. But we don't see it applied in state court that often. But here, the bankruptcy court said, well, and we also have cases in Florida, and there's cases in other jurisdictions that say that a fraudulent transfer is not fraud. It's actually just either some states consider it a statutory remedy, which is what Florida has said in prior cases. This is just a statutory remedy for creditors. It's called a fraudulent transfer, but it's not the same as your garden variety fraud. You have other courts. Nevada's approach is that it's an equitable remedy, allows creditors to simply unwind certain transactions, but it's not a basis for conspiracy. It's not a basis for criminal action, etc. The bankruptcy court here looked at it differently and said, one, that fraudulent transfer, that constitutes a fraud that allows us to get to your privileged communications under the crime fraud exception. The court also used the rationale that the bankruptcy trustee takes over the debtor's estate, and the bankruptcy trustee becomes the de facto owner of the assets of the debtor during the bankruptcy to make sure that the assets get paid out to creditors properly. And one of those assets was the attorney-client privilege. So the trustee was entitled to discover that communication with the attorney, and they went a step further and said that not only can I get the debtor's communication, or can the trustee get the debtor's communication, but the trustee can get the communication of the boyfriend with the attorney under another concept, this joint client common interest. If me and my spouse, or if Gary and I go to somebody for legal advice and we talk to that attorney, and whatever communication Gary has with the attorney regarding that specific legal advice, I am entitled to to be privy to the same information because Gary and I are the joint client. We have a common interest, and so that communication is protected among Gary and I and the attorney, but I'm entitled to discover what Gary said and vice versa. Hopefully I've covered that well, but there's another exception I want you to be aware of, and that's the takeaway from this case, is that by filing for bankruptcy, the debtor exposed all of the personal and confidential private communication between her and her attorney.
That's crazy, yeah.
And between the boyfriend and the attorney. Right? I don't remember who the debtor was, the boyfriend or girlfriend, but the couple and the attorney was all exposed.
Yeah.
That would never happen in state court. And we've got
the last one's related.
About 10 minutes. Yeah, so we've kind of covered the background a little bit on the on fraudulent transfer. And so we've got a similar case with the bankruptcy court now treating a fraudulent transfer differently. And this is one we've touched on before, but I think it's important enough to keep ringing the bell on it. And that's this Husky International Electronics v. Ritz. And here, this was a very common situation that we see. Ritz was had an interest in a company. It wasn't even solely owned by him, but he had an interest in a company that became subject to that owed money to this Husky International Electronics, and he was involved in causing certain funds and assets to be moved from one company to another company. That, again, that's not that uncommon. People, I think, that clients, they unfortunately sometimes tend to consider, disregard the corporate formalities and just move assets between bank accounts, move money between bank accounts. You shouldn't do that, but it's not uncommon, and there's nothing, I don't think there's anything that you consider fraudulent about it.
No, it's a fraudulent transfer, but here's where we get to what Eric's touching on, is this fraudulent transfer idea is treated differently in the law than fraud. we had mentioned fraud. There's this attorney-client privilege exception. There's different. It's pleaded differently in the courts. The penalties are different. Fraudulent transfer is just a way to reach assets that were moved to avoid a creditor. Fraud is a whole different ballgame and creates a lot more problems typically for the debtor. So here we go. So this debtor, Ritz, is creating fraudulent transfers by moving assets from one subsidiary to another. And let's see what the Supreme Court says.
So he gets sued on the fraudulent transfer, which again is just a statutory action. You don't have to plead a misrepresentation. You don't have to plead everything that you would have to in a normal fraud claim. You don't have punitive damages available. You can't sue people for conspiracy. And we have 2 Florida cases where attorneys or financial advisors, with the Payne-Weber case and the Freeman case, where attorneys and other advisors were sued in a fraudulent transfer conspiracy action or for aiding and abetting a fraudulent transfer, and the Florida court said no, fraudulent transfer is not fraud. There was a recent case, Cato Company in Nevada, same thing. Fraudulent transfer is not fraud. But here, when Ritz moved the assets, he sued for fraudulent transfer. He himself files for bankruptcy. Now you have to understand a separate concept here. We got about 6-7 minutes. Again, if you have any questions, fire them out there. We'll try to address them, or afterwards, we're happy to address them. But I want to finish this on Ritz here. In bankruptcy, you come clean, and you're entitled to a discharge of all of your debts. You subject your assets to the bankruptcy court, and you get a clean slate. And it works for people. If you haven't had it, you don't have any assets, and you just got a bunch of debt, you go file for bankruptcy. You get a fresh start. There's an exception. You don't get to discharge debts relating to money or property or services that are obtained by fraud, and that's in the bankruptcy code. So I can't go rip somebody off, profit from that, and then they sue me, and I go discharge that debt in fraud, in bankruptcy. Pardon. If I have a client who gets sued for fraud and has a judgment against them for really fraudulent activity, which I haven't had anytime recently, but that is not dischargeable in fraud. But I'll tell you, I have argued, taken one of those cases to trial in bankruptcy court on the other side, on behalf of a creditor suing a debtor to get an exception to discharge. Essentially, you keep the debt alive after the bankruptcy. The debt never goes away. It's like you have it for life. And I was successful against this criminal Vermilio. What he did was, I think, close to criminal act. And Judge Briskman in the bankruptcy court here in Orlando agreed, and that debt survived the bankruptcy. But it's a very, very high standard to get an exception to discharge based on fraud. Here, the creditors brought an action to say, no, you can't get rid of this debt that arose from the fraudulent transfer because it's fraud and it's an exception to bankruptcy. I would have never thought that claim could fly. And here, it went to the district court in Texas, it went to the Fifth Circuit Court, and went up to the Supreme Court after Justice Scalia passed away. So there were 8 justices. All 8 Supreme Court justices agreed that a fraudulent transfer was fraud. In fact, it wasn't even hardly argued in the bankruptcy, in the Supreme Court. In the oral arguments, the topic came up, and they basically conceded that, yeah, we're not arguing that a fraudulent transfer is not fraud. They were arguing under under a different concept. I don't want to go too far in depth because we could talk about
that. But the upshot of that is now, if fraudulent transfer is fraud, right? Now you get back into this thing. If I talk about a fraudulent transfer with my attorney, is it protected by the attorney-client privilege? Am I subject to penalties?
Yeah, we've got the Supreme Court of the United States now equating a fraudulent transfer to fraud. And I know if there's other litigation attorneys, if there's bankruptcy attorneys out there, and this has come up before, people say, well, that's limited to the bankruptcy context, Section 523 in the Bankruptcy Code. I get that. I understand it. But if you go, it's a short opinion. And by the way, the outline that we put in the out for everybody in the box here, we have citations to all of the cases that we discussed today, and I can give you copies of those cases if anybody wants a copy. That Husky case is pretty short. When you read the case, the court's language is not limiting. They're talking about 523. It's in the context of bankruptcy, but there's a broad. It's Justice Sotomayor who writes the opinion. It's a very broad language equating a fraudulent transfer to fraud. And this is this just came out, it was a 2016 case. And so the reason we harp on this thing, is, as Gary said, is now what's going to happen to these cases, for instance, in Florida? You know, is somebody going to come back? You know, back in 2003, actually it was David Cohen that argued that USB Payne Weber case where an attorney was sued here in Florida for aiding and abetting a fraudulent transfer, and the Florida court at the time, the 5th DCA, said no, a fraudulent transfer is not fraud, there's no aiding and abetting. 2016, 2017, if that happens again, an attorney is going to sue
They have to.
an advisor. It's going to be an accountant, a financial planner, a banker, or another lawyer for conspiracy, aiding and abetting something in connection with a fraudulent transfer, and they're going to cite this Husky case. And that's why we harp on this so much, because you're nice enough to attend this webinar with us, and we want to keep you out of trouble. Seriously, so an attorney's going to get sued on this.
It's going to, and if it's a bad enough actor, they're going to apply it, and we're going to be stuck with fraudulent transfers being fraud.
And so we're really just waiting for that to happen, and that's what happened in Husky, and it all originated in the bankruptcy court. So that's kind of the theme for today. We're finished the main part of our session. We have a little time to take any questions if anybody's got any. We put a few more notes in the outline, some advice to avoid bankruptcy, and finally your continuing education credit numbers for today. We have a CLE number. This is for the attorneys. CLE number, please use 1707328N as in Nancy. I'll say that again. CLE number for attorneys is 1707328N as in Nancy. For the
CLE credit.
The continuing education from the CFP board for the financial planners out there. We've got number 2464560. Again, the CFB number is 2464560. The CPAs here in Florida don't get a number. We do have other information if you need the verification. We keep the attendance, and we can provide that by email. Happy holidays, everybody. For those who joined us last month at our happy hour, we had a great turnout. We appreciate everybody coming out. For those who followed us in the webinars, we appreciate your support. If you'd like to have us come speak at any events, seminars, webinars, otherwise, do a roundtable, cover any of these topics in more depth, we're happy to do that. I think we're going to meet with a group here next month to talk about a case. We've got about 8 or 10 folks, and we'll get some continuing ed credit for that. And then we are going to resume our seminar series. We're going to finish up with Commandment 11, don't invite others to the party. We're going to talk more about the potential, some of the ethical issues, and its morality, legality, and ethics in asset protection, some of the good and the bad and the ugly. We have applied for, we'll have CLE credit for that. We've applied also for ethics credit. I imagine we'll get that, so I know a lot of the attorneys need ethics. We're approaching the 1 o'clock hour. Again, thank you very much. And if you have anything for us, I'm Eric, and I'm with Gary. We are at Forster, Bowman, and Lefkowitz, and we are Bowman at FBL-law.com or Forster at FBL-law.com. Thank you all very much, and have a great holiday season. Bye-bye.